Ready? 5, 4, 3, 2, 1, start. This court, while deciding the appeal filed by the Union of India, came to the conclusion that the grounds which weighed with the High Court were special and merely because the employee was acquitted by the criminal court, it does not mean ipso facto that he is entitled to be reinstated in service, since he was dismissed from service after facing a disciplinary proceeding. The reason being that the disciplinary proceedings are governed by a different standard of proof, which are different from what is applied in a criminal proceeding. Whereas in a criminal trial, the burden lies on the prosecution to establish the charge beyond reasonable doubt, and in a departmental proceeding, the charges have to be proved on the basis of preponderance of probabilities. In the above case, a distinction has also been drawn by this court between a criminal offense and misconduct. One has to be proved in a criminal court, the other in a departmental proceeding, and though both may arise from the same set of facts, yet there is a clear distinction between the two, and merely because one has been acquitted in a criminal trial, it would not amount to a reversal of the findings of misconduct which were arrived in a departmental proceedings. Next para. This court also observed that the High Court fell into an error in doing exactly this, which was done by drawing an erroneous inference from the decision of this court given in Capt. Anthony. We must therefore reproduce here the two paragraphs from judgment of this court in Sitaram Misra. The fact that the first respondent was acquitted in the course of the criminal trial cannot operate ipso facto as a ground for vitiating the finding of misconduct which has been arrived at during the course of the disciplinary proceedings. The High Court, in our view, has drawn an erroneous inference from the decision of this court. The High Court adverted to the following principle of law laid down in the above judgment. While in the departmental proceedings, the standard of proof is one of the preponderance of the probabilities, in a criminal case, the charge has to be proved by the prosecution beyond reasonable doubt. The little exception may be where the departmental proceedings and the criminal case are based on the same set of facts, and the evidence in both the proceedings is common without there being a variance. Next para. It is undoubtedly correct that the charge in the criminal trial arose from the death of a co-employee in the course of the incident resulting from the firing of a bullet which took place from the weapon which was assigned to the first respondent as a member of the force. But the charge of misconduct is on the ground of the negligence of the first respondent in handling his weapon and his failure to comply with the departmental instructions in regard to the manner in which the weapon should be handled. Consequently, the acquittal in the criminal case was not a ground for setting aside the penalty which was imposed in the course of the disciplinary inquiry. Hence, having regard to the parameters that govern the exercise of judicial review in disciplinary matters, we are of the view that the judgment of the division bench of the High Court is unsustainable. A three-judge bench of this court, in another case, held the position of law was explained as follows. In our judgment, the law is fairly well settled. Acquittal by a criminal court would not debar an employer from exercising power in accordance with rules and regulations in force. The two proceedings, criminal and departmental, are entirely different. Next para. They operate in different fields and have different objectives. Whereas the object of criminal trial is to inflict appropriate punishment on offender. The purpose of inquiry proceedings is to deal with the delinquent departmentally and to impose penalty in accordance with service rules. In a criminal trial, incriminating statement made by the accused in certain circumstances or before certain officers is totally inadmissible in evidence. Such strict rules of evidence and procedure would not apply to departmental proceedings. The degree of proof which is necessary to order a conviction is different from the degree of proof necessary to record the commission of delinquency. The rule relating to appreciation of evidence in the two proceedings is also not similar. In criminal law, burden of proof is on the prosecution, and unless the prosecution is able to prove the guilt of the accused beyond a reasonable doubt, he cannot be convicted by a court of law. In departmental inquiry, on the other hand, penalty can be imposed on the delinquent officer on a finding recorded on the basis of preponderance of probability. Thus, in the present case, the learned single judge as well as the division bench of Rajasthan High Court were clearly wrong in interfering with the order of disciplinary authority of the Rajasthan police. It is the disciplinary authority which is best equipped to reach a finding whether a misconduct has been committed. Stop.